I'd like to call to order the Milan Area Schools Board of Education special meeting for Tuesday, November 25th, 2025. Would everyone please rise as you're able for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you to everyone attending this evening, as well as those who will be watching the recording. All board members are present except Ms. Heike is excused and Mr. Burdette is excused. And both of our student board members are excused for Thanksgiving break. First up on the agenda is communications and community engagement. Time for public comment. Reminder that this meeting is a meeting of the Board of Education in public for the purpose of conducting the school district's business and is not to be considered a public meeting. There are 2 times for public participation during the meeting as indicated in the agenda. When addressing the board, you will be asked to state your name. The board determines the amount of time granted to individuals or groups to speak. Each person shall be allowed to speak for up to 3 minutes. Board members may question speakers but are not obligated to answer questions or make statements or commitments in response to issues raised by the public. In general, such items will be referred to the superintendent for advisement, investigation, study, and/or recommendation, or designated as future agenda items for board consideration. Are there any students who'd like to address the board? Are there any public members who'd like to address the board? All right, we will move on to routine matters for approval. I need a motion to approve the minutes of the regular meeting of November 12th, 2025.
Motion by Pryor.
Support by Gutierrez.
It's been moved and supported to approve the minutes of the regular meeting of November 12th, 2025. Are any questions or corrections? Hearing none, it's been moved and supported to approve the minutes of the regular meeting of November 12th, 2025. Ms. Murray?
Thank you. Pryor,
Yes.
Sislo,
Yes.
Yes.
Gutierrez,
Yes.
Murray, yes, and motion carries 5-0.
Next up, I need a motion to approve the minutes of the regular meeting closed session of November 12th, 2025.
Moved by Gutierrez.
Support by Farrow.
It's been moved and supported to approve the minutes of the regular meeting closed session of November 12th, 2025. These are on the envelopes in front of you. You can pass them in if you have no concerns. All right, it has been moved and supported to approve the minutes of the regular meeting closed session of November 12th, 2025. Ms. Murray?
Thank you. Sislo,
Yes.
Farrow,
Yes.
Gutierrez,
Yes.
Murray, yes, Pryor,
Yes.
motion carries 5-0.
All right. Now we will move on to strategic plan business in the area of finance and operations. We're going to have a section 31AA update. This is in regards to state funding, commonly known as safety and mental health support money from the state. There's been a lot of things going on with this with the budgeting process. Mr. McMahon is going to provide us an update, and then we will perhaps entertain a resolution in regards to the update. So, Mr. McMahon.
Mr. Sisler, thank you. As much as I don't like to read prepared statements, I'm going to read a little bit of this one because I want to make sure I get all the details right. So the discussion here is about Section 31AA. That's the section in the law that regulates this grant funds. The funds are allocated at, or at least calculated initially to be $140 per student, which for us would equal about $238,000 for this year. That is if every student or every district participates. What's not clear in the language is if they'll reallocate if some districts do not, so it could potentially be more, but for now it looks like it would be a little over $238,000. This funding must be directed towards student mental health and school safety. This wouldn't be the first time we've had this funding. We used it in the past to fund our district social worker who handles McKinney-Vento and our foster care students, as well as social work responsibilities. And also it's funded our F504 coordinator district-wide. We've even used it to provide our Be Nice program. It was a 2-year contract. And then our DESA mental health screener, we're all funded through the 31AA funds. This year, in order to get the funding, you have to agree to some stipulations. This is new in the law, and the stipulations are if they're conditions following a mass casualty event. And so there's 3 stipulations. It's that you be subject to a comprehensive investigation, 2, you'd waive any privilege that would otherwise protect related information from disclosure, and 3, fully comply with the investigative process. So there are some concerns that districts have been discussing over the past month or so. The first one is mass casualty. The definition is not clear. Right now, the language says it could be triggered by significant injuries to not fewer than 3 individuals, a fatality, a demand that exceeds local emergency response capacity, or a sudden and timely surge of emergency services. There was an example it was 2 weeks ago now, at a district in our county. We're at a football game. 2 students got injured on the field separately. The first got taken off in an ambulance. The second needed an ambulance, and there wasn't one there. A referee got hurt, and then a parent fell in the parking lot. So we had 4 injuries at one event, which could technically, by definition, trigger a mass casualty event. It's not clear whether that would or not. I don't think that's the intent, but that's some confusion around the law. The second condition is attorney-client privilege waiver. This is a long-standing legal protection offered between clients and attorneys, all clients and attorneys. It was even brought up in a webinar that was hosted by a law firm that even criminals maintain attorney-client privilege. That's not waived. And most lawyers, if not all lawyers that you talk to, would say they would never suggest waiving that privilege. And it's in place to promote sound legal advice. It also brings up questions for us if we were to waive privilege about FOIA, Open Meetings Act, and FERPA considerations, which are protections we have in place to protect our students. And if we're not able to do those things, that might divulge student information, which is also against the law. So there's some confusion there. And the third concern that districts are talking about is the timelines. It's not clear if you opt into these funds, if that means any event that occurred at any time in history is now subject to a waiver of attorney-client privilege, or if it continues into perpetuity, or if it's defined by just when the grant funds are available. So there's certainly some lack of clarity there. If the funding is only for 2 years and there's stipulations around it, but the waiver goes on in perpetuity, then that would impact boards and superintendents and employees forever. And so that's a concern. The original deadline to opt into the funds was November 30th, just following when they passed the budget. More than 30 districts 2 weeks ago filed a lawsuit, and because of that, the deadline to opt in has been pushed to December 4th. Troon Law Firm, which represents us, has prepared an amicus brief, which includes us. It's in support of the lawsuit as a district that's not included in the lawsuit, so it's just to provide supporting documentation. Our district, along with 176 others, have signed into an open letter that was sent to the governor, the House of Representatives, and the Senate to support the injunctive relief that's sought by the lawsuit. The Michigan Department of Education has since added an opt-out period of December 30th. So now the opt-in period deadline is December 4th, but they created an opt-out on December 30th, which allows you to rescind your opt-in. So these are strange regulations they're putting on that most grants, well, I've never seen a grant have this before. And the biggest concern for us is not the investigation, because we would certainly comply if there was what could be considered a mass casualty event, but it's the timelines that are not clear and the waiver of attorney-client privilege that is not well defined. Troon has also prepared a resolution for the board to consider, which we can talk about tonight. It provides guidance to the district about opt-in and the rescission date of December 30th.
Thank you, Mr. McMahon. I know there's been several MESB webinars that several of us have attended in regards to this and heard opinions in regards to. As Mr. McMahon stated, there's a lot of ambiguity around this, and the one major concern is that waiver of attorney-client privilege and just not understanding the timelines of that, how that impacts our staff and us as a board, and how that impacts those folks into perpetuity. So it is it's an unfortunate piece of the budget that's led us down this path, but it's the reason that we called this special meeting, is to consider this because of the timelines with the lawsuit that is upon us or upon the state in regards to this grant money. So other thoughts in regards to before we consider a resolution from Troon? Other thoughts? Ms. Gutierrez.
Thank you, Mr. Sislo. I appreciate this conversation, and it's something that I know has been on the minds of many of us, both here in Milan area schools, but also in other districts. This is a question for maybe Andrew and Mr. McMahon. What I haven't fully understood is that whether or not, if we were to opt in and then later opt out, if in that intervening time, if we would be subject to the stipulations in here. So for that period of time, would we lose our attorney-client privilege, and so forth? And I ask that question because I think it does open us up for concerns about some of these questions about FOIA, open meetings, FERPA, and so forth. And I would hate for us as a board to make a decision that we think we can back out of, but would have important ramifications perhaps for student privacy and so forth in those intervening weeks if it was immediately enacted.
I can answer that. Yesterday I was in a webinar hosted by MASA, but helping deliver or on the panel was the lead attorney from Miller Canfield, who's leading the lawsuit of the more than 30 districts to the state. And they asked that question of the legislatures, and they clarified that you waive those privileges or any of the requirements upon receipt of the funds. So if you opt in before December 4th and choose to opt out, you are not in a period where you would have to agree to any of those terms.
As a follow-up then, because the timeline of our receipt of funds would be when?
It's like December 31st.
December 31st.
They pushed it to the very deadline, yeah. So there's actually a possibility that districts that wait till the last minute to opt out or rescind their opt-in
Would actually get funds.
they might actually get the funds, and then they would start pulling back from state aid payments.
I
But
see.
once you get the funds, if you've opted out, you are out.
Okay. And my second question is that whether or not our legal team has reviewed the document about the opt-in, opt-out, and have confirmed that that is legally sound and that that's something we're comfortable with.
Yeah, and that's included in the resolution, so they actually address, it was, the decisions are coming fast
Yeah.
with these, but Troom was able to have that language in the resolution to talk about December 4th and 30th deadline.
Good questions. Others? Let me go ahead and offer the resolution. We can still have a conversation after discussion, but I'll go ahead and offer this resolution so that we can have further discussion if there's any concerns about the resolution. So whereas Public Act 15 of 2025 amends the State Aid School Act Section 31AA, MCL 3881631AA, which is that's the number of the law, to allocate funding for fiscal year 2025-2026 to support school safety and student mental health initiatives, as well as to provide certain competitive grant funding, better known as 31AA funding. And 2, to receive 31AA funding, the district must agree to receive the funding in the form and manner established by the Michigan Department of Education, MDE, and either formally opt in or seek a competitive grant. And as a condition of receiving either type of 31AA funding, the district must agree that in advance, in the event of a mass casualty event as defined in MCL 388.1631AA, 1, the district will be subject to and comply with the comprehensive investigation following such an event, and 2, the district will waive any privilege that may otherwise protect related information from disclosure, and 4, litigation challenging the legality and enforceability of the privilege waiver requirement is currently pending, and 5, the opt-in deadline for 31AA funding is currently December 4th, 2025 at 11:59 p.m., and it may be subject to further extension, known as the opt-in deadline. And 6, the litigation parties have stipulated that a district may later rescind its opt-in by providing notice to the MDE no later than December 30th, 2025 at 11:59 p.m., as may be subject to further extension, known as the rescission deadline, in the form and manner established by MDE, and The board has been fully advised of the legal and practical implications of the privilege waiver requirement, including its potential effect on attorney-client privilege and other applicable privileges. And 8, the board desires to preserve the district's eligibility for 31AA funding while avoiding any present waiver of privilege and while allowing time for the courts to determine the legality and enforceability of the privilege waiver requirement. So that's the setup. Now therefore be it resolved that 1, the board hereby authorizes the superintendent of schools or designee to submit the district's opt-in form to MDE on or before the opt-in deadline solely for the purpose of preserving the district's eligibility for 31AA funding and only on a conditional basis as provided in this resolution. Submission of the opt-in form shall not constitute a present waiver of the attorney-client privilege or any other privilege. 2, the district's conditional opt-in shall be automatically rescinded without further action of the board unless on or before the rescission deadline, A, the legislature removes, substantially amends, or otherwise eliminates the privilege waiver requirement such that the acceptance of 31AA funding would not require waiver of attorney-client privilege or any other applicable privilege, or B, a court of competent jurisdiction rules that the privilege waiver requirement is unlawful, unenforceable, or otherwise not applicable to the district. If neither A nor B occurs by the rescission deadline, the superintendent of schools or designee shall notify MDE in the form and manner required by MDE no later than the rescission deadline that the district's opt-in is rescinded. Number 3. If the privilege waiver requirement remains in effect and enforceable as of the rescission deadline, the superintendent of schools or designee shall have no authority or obligation to accept 31AA funding. Number 4. Nothing in this resolution shall be construed as a waiver of attorney-client privilege or any other applicable privilege. Number 5. The district's participation in the opt-in or rescission process shall not be construed as a waiver of the board or district's right to challenge the legality or enforceability of any condition imposed by MCL 388.1631 AA or related administrative guidance. 6. If, after the rescission deadline, the privilege waiver requirement is removed, amended, or invalidated, the board may take further action as it deems appropriate to pursue 31AA funding consistent with applicable law. And number 7, this resolution does not apply to any mass casualty event occurring prior to the opt-in deadline. So, and one more thing, all resolution and parts of resolutions insofar as they conflict with the previous provisions of this resolution, B and the same are hereby rescinded. So I would ask for somebody to make a motion to accept that resolution.
Moved by Farrow.
Support by Murray.
All right, it's been moved and supported to approve the attached resolution as read by myself. So I think a little bit of that did also answer Ms. Goodyear's question about the timing, and it really a lot of this is the timing of the lawsuit. The judge has indicated that they're going to hear the case the 1st of December, and will make has intentions of making a decision by December 3rd, which is why these deadlines have been set in this way. But it's a lot of things can happen between now and December 4th. So now that we do have this opt-in or this rescission period until December 30th, I think this is a prudent resolution that's been offered by our legal counsel. Other thoughts? Ms.
Mr.
Gutierrez?
Sisler.
Yeah.
So just if, I want to reiterate what I was hearing in there that I
Yeah.
think might be important for our community, and please correct me if my misunderstanding is incorrect. So what I understand that resolution to do is to allow Mr. McMahon to opt in, but set parameters by which we would not need to take further board action to authorize him and frankly direct him to opt out if the attorney-client privilege mandate is not removed or found to be unlawful, correct?
That's correct. That's what
Yes.
that's what this reads as.
Yep.
So we wouldn't have to take further action, but we do have two board meetings in between the date that we're supposed to get a decision by the judge and the rescission period. So we have meetings on December 10th and December 17th that we could provide further a further resolution in regards to that. But you are correct. So I mean, in the case that we do not have any of those meetings, that sets that up. So if the attorney-client, if those two items are not met, especially the waiver of the privilege,
Correct.
this directs Mr. McMahon to rescind our opt-in.
And so those parameters are set ahead of time with what would be essentially our kind of no-go decisions to opt out, which would be about the attorney-client privilege.
Yep.
Okay, thank you, and I think that's important for our community to understand.
That's
Yep, no, that's
Yep.
exactly right.
Yep. Other questions or comments? Ms. Murray?
I will just chime in first with appreciation to Mr. McMahon and all of our district team members who have been following this so diligently, and board members who've attended MASB seminars. I've been reading along but have not made it to those. But I think I'm prepared to support this resolution. I think that it does a good job at both preserving our capacity to opt in for those funds, which, $238,000 in our district is not chump change. It's represents significant programs and people to our district. But as Ms. Gutierrez stated, sets up conditions for us to be able to maintain protections for ourselves, for our students, for our district, and all of the people who work so hard here. My personal long-term position continues to be that unless binding and statutory changes are made to the law itself or it's struck down in court, that this is not safe money to accept for all of the aforementioned reasons in the resolution, and as Mr. McMahon explained. This would not be a thing that I would be comfortable accepting a guidance memo from MDE or a statement of legislative intent. None of those things to me would be sufficient in order to move forward with accepting these funds and assuming those liabilities. So yes, again, I'm in support of this resolution at this time, but yeah, we'll continue to be vigilantly watching as this moves through in the next few weeks. Thank you.
Yeah. Others? All right. So it has been moved and supported to approve the attached resolution that, as read by myself. Ms. Murray?
Thank you. Farrow,
Yes.
Gutierrez,
Yes.
Murray, yes. Pryor,
Yes.
Sislo,
Yes.
and motion carries 5-0.
All right. On to other business. I need a motion to enter into closed session to pursuant to Section 81C of the Michigan Open Meetings Act for negotiation strategies.
Moved by Pryor.
Support by Gutierrez.
It has been moved and supported to enter into closed session pursuant to Section 81C of the Michigan Open Meetings Act for negotiation strategies. There will be no further business before the board except for adjournment when we return to open session. Any other questions or comments? All right. Happy Thanksgiving. Thank you to everyone for watching and attending. We are going into closed session at 5:50. Oh, yeah, we do have to vote. I'm sorry. It's been moved. Yeah, thank you. It's been moved and supported to enter in closed session pursuant to Section 81C of the Michigan Open Meetings Act for negotiation strategies. Ms. Murray.
Thank you.
Sorry.
That's okay. Farrow,
Yes.
Gutierrez,
Yes.
Murray, yes. Pryor,
Yes.
Sislo,
Yes.
and motion carries 5-0.
No, thank you. We can go into closed session at 5:55 p.m. Thank you. All right, we are returning to open session at 9:12 PM and we are adjourning at 9:12 PM.